welcome everybody. I'm Sarah Flack, Housing Grant Manager at the City of Evanston, and we are hosting this webinar on guidance for renters during COVID-19 because we're all trying to deal with things that we've just never had to deal with in our lives before as renters or just people, frankly. So we've got Xavier Reeves and Philip Devon from the Metropolitan Tenants Organization here, and also Jonathan Ratzenberger to talk about ways that tenants can work with their landlords, how to deal with things that have come up as a result of COVID-19, as I say, that we've never dealt with before, and hopefully give you a lot of useful information. I'm going to turn this over now to Xavier and Philip to get going, and then later on you'll hear from Jonathan. So thanks again for coming to our webinar, and I hope it's helpful for all of you.
Well, thank you, Sarah. Thank you very much. I'm going to go ahead and share my screen here with you all. Let's see if this is working correctly. Okay. So, can everyone see this, hopefully? Okay, great. So, the Metropolitan Tenants Organization provides tenants' rights, resources, information, as well as support for any renter in the city of Chicago, the surrounding suburbs, which includes Evanston and Cook County. And tonight we're going to be kind of going through a truncated version of what your rights are in general, but particularly with a focus on how you can navigate some of those rights and issues during COVID-19. So with that said, if nothing more, make sure you get our contact information. I know we're going to go through a lot of information in a fairly quick amount of time. So make sure you get our contact information during this presentation. You can always go to tenants-rights.org and go to the contact us page and just drop us a line. We're very quick to respond to those emails through the website. So with that said, what we're going to go through today, and this will be a fairly brief presentation, I'll be going through mostly the Evanston Residential Landlord Tenant Ordinance, and I'll be going over some other common problems that tenants have with repairs and essential services. And Jonathan will be finishing up talking about evictions and lockouts during COVID-19. So please also, Javier is moderating. Please make sure to chat a question, even if you think of it now. Feel free to send that while I'm talking so that we can make sure we answer that. We'll have plenty of time for questions at the end of our spiel. So,
and just quick FYI, it says my name is on the screen is John Bartlett. Obviously not my name. My name's Javier, but just message the questions right here to John Bartlett, and we'll have them ready when it's time for Q&A.
Yes, thank you for pointing that out. Send your questions to John Bartlett, AKA Javier Ruiz. So let's just get into it. I know I've probably burned through several of my allotted minutes already. Governor Pritzker has issued a stay-at-home order. This is not news to anybody, but just as a quick reminder, that order does not apply to essential services, including physician, vet visits, grocery stores, things like that, public transit included. Of course, everyone wants to practice as much social distance and other safety precautions as they can if they do have to leave. Doesn't prohibit you from moving. That's a common question. And unfortunately, right now, for some people, moving is unavoidable. And if you do have to move, you, again, just need to do the best you can and consult with maybe MTO about how you can best protect yourself through that process. But the order does prohibit your landlord from showing occupied units right now. Landlords can show apartments that do not have a tenant in them, but a landlord who could normally give you 2 days notice and show your unit to a prospective renter can't do that right now. So that's important to know as well. As I really say, anytime I'm talking about renters' rights, one of the most, if not the most important thing you can do, no matter what the situation is document what's happening, and do so in writing. So this advice really is important now, especially because a lot of the problems that might come from a COVID-19, say a rent issue, really will come to a head later on down the road once courts reopen and things get moving again. So any agreements, anything that you agree with your landlord or any deals you work out, you want to make sure you get that in writing. But right now, for anyone that thinks they might have an issue paying rent or might not be able to make rent, they really should immediately contact their landlord. I'd urge them to even contact MTO, call our hotline, or go to our website. Again, you can send us contact us. It's down there at the bottom. Because hopefully you can see it says here, we can give you letter templates. We have letters for all market rate renters who want to approach their landlord and start documenting this if they fear that they might not be able to make all of their rent. We also have, if someone is subsidized, say they have a housing choice voucher or they live in a HUD building, we have letters that they can send to their landlords as well. Because quite frankly, a lot of folks have had a loss of income, have had a financial hardship due to this. And so for folks with a subsidy, you want to get a recertification. And for those of us that pay market rate, we want to make sure, if we can't, that we're documenting this and getting something worked out with the landlords or your landlord. We actually, even since I'm mentioning landlords, if anyone happens to be a landlord or knows somebody, we get a lot of calls from small mom and pop landlords. We're having a similar training next Wednesday at 6 p.m. We'll be posting that on our Facebook. Evanston sending that on their newsletter, and you'll be able to get that information also just by contacting us. And 2 weeks from tonight, on Wednesday again at 6 p.m., May 6th, we'll be doing a Spanish version of this tenants' rights training for all Spanish speakers. So please spread the word about that as well. And so we'll be talking more next week in the landlord training about things like this, but a lot of smaller landlords might not know about mortgage forbearance and other things that are available to them right now. So let me go through what is really the main law in Evanston that governs the rights and responsibilities of renters and landlords. The Evanston RLTO is really similar to the Chicago law. It covers the right to repair, protections against retaliation, and certainly many more topics that we won't even discuss today, like security deposits, what type of disclosures maybe a landlord needs to give you before you move in, things like this. But of course, get our contact info, reach out to us, because any of those questions we can certainly answer. And you can access the Evanston RLTO in full on our website, as well as just by Googling our Evanston RLTO. It's the first thing that pops up. Obviously, this law still applies. Some people have asked that, and that's a great question. This law is not suspended during a pandemic. MTO would argue that it's even more important during a time like this that people are taken care of. Quickly, written leases. Really, we don't need to spend too much time on this, but a reason a written lease, and again, documentation is everything. Getting things in writing is everything. And this kind of shows why. If you're on a month-to-month agreement, or also known as just a verbal lease, a landlord in Evanston can give you a 30-day notice, and you would be required to move as long as they gave you that notice timely. But they can't do that with a written lease. Of course, they would be able to do that at the end of your written lease, say, 30 days before it expires, they could send you a non-renewal notice. But written leases are typically a year in duration. They're really important because you can't change the rules during a lease. And for some of you, these things may seem like, oh, duh, but a lot of people are subject to, rule changes mid-lease and things that end up happening or that they subject to that they really didn't have to. On the flip side, if you're, make sure if someone tells you something, particularly landlord, particularly if it's about rent right now, especially, put that in writing. Oftentimes people don't bother because they don't think that their landlord will sign it. Even if you have a verbal conversation, it would be, and they won't sign anything, it's advisable to send them an email or write a letter right after that, just saying, I wanted to follow up on the conversation we just had and really summarize it. And that's a way to document things. So please do that. The Evanston RLTO requires that landlords maintain your apartment and actually follow the building code. Tenants are not responsible for normal wear and tear. I know it's normally a big moving season. It's not right now, but a lot of tenants do get charged and dinged for what really is normal wear and tear. So again, documentation, protect yourself from things like that by taking photos when you move in, photos after you clean before you move out. Landlords are responsible for maintaining common areas. That's often a problem, and the Evanston RLTO is clear about that. And any repairs or upgrades that are promised in the lease. Of course, it's important to get those things in writing. I myself have been a tenant in a situation where I did a walkthrough and said, oh, and I was told this will get painted and that'll get done. And when I moved in, unfortunately it wasn't done, but I had no recourse because I really didn't get it in writing. So again, documentation is key. What happens under the Evanston RLTO if I do have repair issues? What does the RLTO say that I can do? Well, it really gives you three main options, and these aren't all your options, but I'll go through three of the bigger options. A repair and deduct letter is the first. In Evanston, what you need to first do is write your landlord a letter, keep a copy, of course, send it certified mail. If you don't think they'll accept it, don't require a signature, just proof of delivery, send it regular mail, email it, text a picture, do everything you can so that you can ensure that they've got it. We all communicate through a lot of different means and channels now, so I always recommend if it's important, send it by every channel that's available to you. After 14 days, so let's say, your kitchen cabinet isn't, or the sink is broken, something that doesn't cost more than $200 or half your rent, whichever is higher. We're all paying usually much higher, maybe closer to $1,000 or $2,000 in rent. So it'd be half of that amount. So these are for things that are really something you could fix yourself that's within reason. If the ceiling's fallen in and there's pipes that need to be repaired, this is not the option for that situation. And of course, in all of these situations, if you think there's a code violation, please do call 311 and report that. Because if you want to take the second option under the RLTO, you're going to have to make sure that 311, the city of Evanston, has actually cited the repair issue as a code violation. And that is rent reduction. Of course, anytime I talk about rent reduction, I like to warn people that it is something that's a bit risky. So anytime someone's going to withhold rent, they need to document all their attempts to resolve the issue before they did that. They need to follow the law closely, really want to consult with a lawyer, and be modest in our experience. We can't tell you what to do as a tenant, but we can say what we've seen in the past. And oftentimes the more that someone withholds, the harder it is to resolve the situation usually. So it can get tenants into places they don't want to go, like eviction court, which John will talk about soon. So if you have an issue that is too big to fix yourself, please call 311, have them come out, cite it. If that pipe is leaking in the bathroom, they'll cite it as a code violation. Then you can give your 14-day letter. And if it's not fixed in 14 days, you can withhold what is reasonably reflects the reduced value of the unit. I know it's tough because there's no magical chart that breaks out, how much you can reduce for each problem. So that's why, again, we encourage people to be modest if they have to get to the point of reducing rent, and really consult with an attorney and someone that might be able to help you negotiate an agreement. Nobody wants to end up in eviction court, and we don't want to burden you or other parties if there's a workaround and a solution. So please, sometimes there isn't a solution or a workaround and you want to terminate your tenancy. So if the issue, like that bathroom ceiling that had caved in, you can't use the bathroom, and you just need to get out of the apartment, then that is probably when you'd want to use this third option under the RLTO, and that's to terminate your tenancy. You need to give the landlord a copy of the notice and wait 30 days after receipt. And if the repairs aren't made, you want to confirm that you've terminated your lease and when you're moving out. And if you do this, you do terminate your lease under this provision, the landlord still must return your security deposit. I know looks like I'm probably already eating into other people's time, so I might breeze through these last slides. But a couple of important things to know about essential services in Evanston, particularly now when it's been still chilly. I know someone like me doesn't need the heat on now, but certainly some elders, even in my building, do right now. So this is important to know that heat is still a requirement through June 1st, especially on these, chilly spring days. If there's contact information for the Health and Human Services Department of Evanston here on this slide. The one in the middle paragraph is during business hours, but if there's a heat or other utility emergency during the weekends, please call the non-emergency number there that you see and ask for the property management inspector on call to be paged. As far as some utilities and essential service stuff to think about right now, the ICC, Illinois Commerce Commission, has ordered a moratorium on all utility disconnections through at least May 1st, or until the governor announces an end to the emergency. That's really important to know because that applies to folks, whether it's because ComEd isn't going to shut off your services right now, but if a landlord does cut somebody's power or utilities, you want to get on the phone with MTO and the police right away. That's an illegal lockout. John will go over that momentarily. Again, call 311, request an inspection. If you're without heat or essential services, again, you need to put it in writing. You need to send the notice to the landlord. You have to give them 7 days. And if they haven't done that, you could either terminate your lease or alternatively, you could pay the cost of utilities and deduct it from your rental payments, or you could procure substitute housing until the problem's resolved. This I normally would spend a little more time on. Basically, landlords need to give 2 days written notice and let you know before they come in. They do have the right to show up their apartment, and if they don't have an emergency, like there's a repair issue, then they do need to give 48-hour notice. Otherwise, they need to leave a note if there's an emergency and say why they came in. But as we talked about before, right now, due to the stay-at-home order, landlords are not allowed to show occupied apartments. And while that is a good thing and it's a right call for safety, it does cause hardship. It's making it more difficult for other people to find apartments. So again, if you're in one of those positions where you're looking for a solution, call us. A lot of these are really nuanced situations that vary, case by case, and we have a lot of experience. We can help, maybe come up with a solution for you. Just also the Safe Homes Act and the Violence Against Women's Act is still in effect. A landlord can't stop you from using one of these laws if you're a victim of domestic violence. And if you are, please call us again. With all of these things, there's really, at least with Safe Homes Act or VAWA, if someone is going to terminate their lease or move or use this law, please reach out to us. We can provide you template letters for every kind of situation and fact pattern that it might fall under. So please contact us if that's an issue. I'm going to pass it over now to Jonathan Raffensperger. He's a staff attorney at the Lawyers Committee for Better Housing. MTO works closely with the Lawyers Committee for Better Housing. And so if you are facing eviction or worried about paying rent and it might need some legal intervention, reach out to us. We can go through that with you. And if need be, we can really expeditiously connect you with someone at LCBH or another agency you might need. So with that said, please take it away, John.
Thanks, Phil. So as Phil said, I'm an attorney with the Lawyers Committee for Better Housing. We're a legal nonprofit that provides free legal services to low and moderate income renters in Chicago and now also in Evanston. We're serving this community as well. You can find our website at lcbh.org. You can reach us on the phone. We're still checking our messages at 312-347-7600. So as Phil mentioned, I'm going to talk a little bit about the eviction process and how that has been changed and impacted by the COVID emergency. I'm also going to talk a little bit about illegal lockouts, landlords trying to force tenants out without, outside of the legal process, and also just a touch on retaliation, which is unlawful landlord actions that landlords are taking because tenants are making complaints that they're allowed to make, as Phil has discussed several means by which tenants can exercise their rights. So first, just to talk a little bit about the normal eviction process, how that would normally work. Eviction is a little bit of a complicated subject in that people think about eviction as kind of the ultimate act when a tenant is forcibly removed from a property, but really it's a process that has a number of steps to it. And that starts with the termination notice. In Illinois, landlords are required to give tenants written notice for some amount of days of written notice before their tenancy be terminated. That could be 5 days, which is the amount of notice required for non-payment of rent. It could be 10 days, which is the notice for a different violation of the lease. It's not payment of rent. 30 days for non-renewals of leases, or if it's a month-to-month tenancy for termination for no cause, or 90 days if we're talking about an eviction as part of the foreclosure process. So the amount of time provided depends on the reason, but for all tenancies, the landlord does need to give you written notice before they can end your tenancy. The second step of the process would be the filing of an eviction complaint by the landlord. It's starting a court case. It's a document that just states, that essentially in very basic terms why the landlord is asking for the tenant to be evicted and saying that they have a right to the property. The third step would be service of a summons by the sheriff. That's delivery to the tenant of a court document saying that the landlord has started a legal action seeking to have the tenant evicted, and telling the tenant, a copy of the landlord's complaint, and telling the tenant where and when they should go and when their court date will be. So the summons is usually first attempted to be served by the Cook County Sheriff. If the sheriff can't find the tenant at the property, the landlord can then use another person, a special process server who might be a private investigator or another individual that the court has approved to find the tenant elsewhere or at different hours at the property. And ultimately, if the special process server can't find the tenant, the summons can be served by what's called posting, which is simply that the landlord tells the court, the landlord's attorney tells the court that the tenant can't be found, and the notice of the case is posted in the courthouse. Is kind of a little bit of a silly assumption that people walk by the courthouse all the time, and would be also mailed to the tenant. So, summons can be served on you even if nobody comes to your door and hands you a thing, if they go through that entire process. So the next step after service is made on the tenant would be the court case. So on the date provided in the summons or on another date later set by the court. So I think we lost the presentation here. So on that date, whether it's the return date or a separate date set by the court, the judge or jury would hear, the landlord's side and the tenant's side, hear the reasons why the tenant should be evicted and the tenant's defenses, and decide whether the landlord or the tenant is entitled to have the apartment and whether rent is owed. If the court decides in the landlord's favor that the landlord is entitled to the property, then the court would issue an eviction order, which is just an order of the court saying that the landlord should, be returned to possession of the property, and that the tenant should be evicted. And, that court order then needs to be enforced by the Cook County Sheriff. The sheriff is the only office that is allowed to evict tenants. The landlord can't just take an eviction order and then go change the locks. The landlord can't, hire somebody else to do that. They need to place the eviction order with the sheriff, and the sheriff's deputies would then come out and actually remove the tenants from the property and post a notice, on the property saying the tenants can't re-enter. So, it's important to remember only the sheriff can enforce an eviction. The landlord, even if they get an eviction order from the court, can't lock the tenants out. Next slide, please. So that's the normal eviction process. Now we're going to talk a little bit, I think we maybe went one too far here. We're going to talk a little bit about how the COVID-19 emergency has changed that normal process. And we can talk about that in the kind of the steps that we just discussed. So as far as service of notices goes, at this time, there's no policy, through the city of Evanston or the state of Illinois that would prevent a landlord from serving a notice to terminate a tenancy. So there's no protection at that level. There is a federal law called the CARES Act, Coronavirus Relief Act passed by the federal Congress, which applies to buildings with federally backed mortgages. Now, that's a little bit of a complicated term. It's very broad under the law. Most residential mortgages are federally backed within the meaning of the CARES Act. So especially if you live in a smaller building that has a mortgage, then it's likely that it will be covered by the CARES Act. Some larger buildings are also covered. So if you do live in a building that is protected by the CARES Act, then there is a federal moratorium on eviction filings and on services of termination notices that goes until July 25th. The law was passed on March 27th, and the period goes for 120 days. So that is an important protection for tenants who are experiencing economic difficulty right now and may have trouble paying their rent. And we can talk a little bit more about that in just a minute. So moving on to eviction filings. Again, at this time, there's no city or state law or policy that would bar landlords from filing an eviction case if a tenant can't pay their rent. But again, that CARES Act, that federal law, does provide protection to tenants and prevents landlords from filing cases for non-payment in those buildings. And then with regard to eviction cases in court, the Cook County Circuit Court during this emergency is not hearing cases except on an emergency basis. So the court is basically closed to eviction cases and won't be, none of those cases will proceed until at the earliest May 18th. Right now, the state shutdown order is through April 30th. That may change. If that changes, the court's schedule for reopening may also change. So this is a little bit of a moving target. This is something you may want to keep up with by talking to our office or by talking to MTO if you have a concern about when court cases will be moving forward again. And then as to issuing eviction orders, the court's closed. Orders aren't being entered, and the sheriff has been ordered not to enforce any eviction orders that have already been entered, again, until after May 18th. So even if you've already been to court and an eviction order has already been entered against you, the sheriff's team will not be enforcing eviction orders, until at the earliest May 18th. So can we continue to the next slide, please? All right, so that's a lot of information that I just dumped on you. So what does that mean for tenants? So the first and most important thing to remember here is that while there are some moratoriums in place and there are some laws protecting tenants right now, there are no laws in place that would excuse tenants from paying the rent. There may be laws preventing eviction cases from going forward, but the rent is still accruing and is still owed, unfortunately. So even though cases aren't moving forward, even though eviction orders can't be enforced, even if you're in a CARES Act property where the landlord can't even give you a notice until after July 25th, the rent is still owed. So then that leads us to the question, well, what can you do then if the rent is owed and you're out of work or your income is being disrupted and you can't pay the rent? So what we're encouraging everyone to do is communicate early, communicate often, talk to your landlord about your situation. Many landlords are also feeling a squeeze here. Landlords have mortgages, especially smaller landlords may not have the resources to pay their mortgage without their rent. So if you ask if you ask your landlord if they have a mortgage on the property, you might be able to inform them that if they do, there's a good chance that under the CARES Act, they're entitled to up to 360 days of mortgage forbearance for small landlords, or shorter period for larger landlords. So if that law gives them some breathing room, maybe they can give you some breathing room too, and work with you on possibly reducing your rent, possibly coming up with some kind of long-term repayment plan that could let you become current. And then I mentioned here, if you live in a larger building of 5 units or more, there has been some data collected about properties that are subject to the CARES Act. If you follow this link here for the National Low Income Housing Coalition, there is a table there where you can search for your zip code and find some limited information about whether you may be protected. I'm not going to go into this in detail here, but there's some instructions here on how to look up your case if you do have a case in court. The cases were extended once and then again by the court, as this crisis has unfolded. So dates are a little bit up in the air. If you do have a case, you should receive a postcard from the clerk with your new date. But if you don't get that, or you're just concerned and want to find out, you can go online and look at the docket and see if a new date has been scheduled for you. You can also call the Cook County Clerk of Court's office and inquire about when your next court date might be. Next slide. I think there's Phil. All right, and then this is just some links. Again, not going to go into it in detail here. The governor's order, the Cook County Clerk, the court's general administrative order, which continues the dates, and then here's some information at the bottom about the CARES Act, the text of the law, and then also some places you might go to find out whether your building is protected by the CARES Act or not.
Yeah, they're live. We're recording again, so we're hoping
Phil, when you get a chance,
we can just get rid of that link.
All right, so move on to lockouts. We had discussed lockouts as a term we use to describe when landlords try to exclude tenants from the property, get them to move out outside of the legal process.
I know.
All right, and so it covers a range of things that landlords can do. Most obviously, changing the locks so that a tenant can't get into the property. Also, plugging locks, removing the doors, removing windows, shutting off utilities, and any number of things that a landlord might do to either keep a tenant from going into their apartment, from using their apartment, or making it uninhabitable in some way. So then what do we do if a tenant is locked out? So the first thing we always advise tenants to do is call the police. This is, an issue that the police are explicitly authorized to resolve under the Evanston RLTO. They're authorized to arrest landlords that are in violation of the law on lockouts, let the tenant back in. So we recommend that tenants have to be present at the property so that they can meet the police, call the police, have them come to the apartment, and see if the police can demand that the landlord let you in. If the landlord refuses to provide access, you should ask the officer to arrest the landlord for failing to end the lockout. And they, as I said, are authorized under the Evanston RLTO to effect that arrest. Any on-duty officer can do that. And if the landlord isn't at the property or can't be brought to the property, ask the officer to call the landlord to see if he can convince the landlord to come to the property and let the tenant in. And in all cases, as Phil said, we want documentation, so ask for a police report. If the officer isn't helpful, you can try to go up the chain of command. You can go to the precinct and ask for a beat sergeant or a watch commander, and remind the police that under the RLTO, every on-duty officer is authorized to arrest and find a landlord that's in violation. So they sometimes we hear from the police that this is a civil matter. They don't want to get involved. It's not contemplated to be a civil matter. This is it's a very serious thing when a landlord's keeping a tenant out of the property, and if an arrest needs to be.
Hey. Don't delete my.
Hello?
Well, are we having another issue? Okay. And then, if the police can't be helpful for one reason or another, this is something where you definitely want to get an attorney involved. So we would recommend that you call Lawyers Committee for Better Housing, 312-347-7600, and let us know what's going on so that we can help you take further steps. So, so this is just a reminder that shutting off utilities is a lockout. It's not, the tenant may still be able to get into the property, but if they don't have power, they don't have water, they don't have heat, they can't very well live there comfortably and safely. And so that is preventing the tenant from making use of the property, and does fall within that lockout provision. Again, you would call the police about that, and also call 311.
Yes.
So then remedies that renters may have outside of the police, they can seek emergency assistance from the court if they're locked out or have the utilities cut off. Unfortunately, that's not an ideal remedy at this time, just because the courts aren't operating under in a normal way, and they may not have you may not have the ability to get that case heard as quickly as you otherwise would. So again, if you're having trouble, this is something where you need a lawyer. Call our office. And then I'll just say a brief little bit about retaliation. If you live in a property that's covered by the Evanston RLTO, it's unlawful for your landlord to retaliate against you because you made a complaint about bad conditions or an unlawful landlord practice to the city of Evanston or to any relevant governmental agency. And it's also a retaliation, and this is something that is especially relevant right now, if the landlord tries to take action against you because you organized or participated in a tenants union. We are seeing tenants try to band together to negotiate with landlords and try to get landlords to be reasonable about modifying rental agreements because of the widespread economic difficulty. And it's not lawful for your landlord to try to end your tenancy, increase your rent, decrease your services because you participated in organizing activity.
So what conduct is retaliation? That can include, as I said, increasing your rent, decreasing services that are made available to you, threatening to evict you, or actually filing an eviction case, or refusing to renew your lease. If the landlord does any of those things within a year of you making a protected complaint, there's a presumption that it's retaliatory, that they would then have to show, a valid reason why they did that. If you believe your landlord is retaliating against you because you made a complaint or attempted to exercise your rights, you should contact MTO, LCBH, or any other legal aid organization and let us know about that so we can help you.
Yeah, and one way, especially for those of you who were here earlier when we talked about repairs, if you have a repair issue, you can use rentervention.com. That's LCBH's app. And you can leave a message on our hotline. That's 773-292-4980. And again, as we discussed before, quick and easy way to get us is through our contact form at tenants-rights.org/contact us. And if you just go to our website, we'll ask a couple quick questions, and then we'll be able to best serve you and answer any questions you have. Also, do follow us on Twitter and Facebook. We'll be having these recordings posted. We will get, as Jonathan said, a interruption omitted version of today's presentation posted. And again, if you just want a copy of the presentation, the PowerPoint itself, or you have a specific question, just go to the Contact Us form on our page and pop that in there. We will get it to you within 24 hours. With that said, I think I'll pass it over to Javier. I think he might have some questions on deck for us. Is that correct?
Yep, got a few questions. And again, we apologize for the interruption, but here's a few questions that were sent in. I'll start off with one. So here's the thing. My landlord has sent me several notices via email that they can't show my apartment. What is the best way to approach my landlord on this matter?
I'm sorry, Javier, you said notices that they can show the apartment or cannot?
Yeah, that they can show the apartment. I'm just word for word what they said.
That the landlord has sent notices that they cannot show the apartment.
No, that the landlord sent notices that they can show the apartment.
That they're asserting that they can show the apartment. So,
Yep.
That's incorrect. The state has confirmed at this point that the stay-at-home order should be interpreted as not allowing occupied rental properties to be shown. That is by a clarification that was made by the Illinois Department of Commerce in FAQ dated April 1st, 2020, and I would be happy to send that to somebody if they needed that to show their landlord.
I also got one via chat. They sent it straight to me. It says, I had a court date, an eviction court date that was during this shutdown. How do I know about or find out when I have to go back to court? I think I'll let John answer that.
Sure. I touched on this briefly, but if you had a court date that was scheduled and has been postponed, the clerk of court should be sending you a postcard with your new court date on it. And that postcard would inform you. If you haven't received the postcard and you're getting nervous about it, I would recommend that you call the clerk of court. That phone number can be found online at the Cook County Clerk of Court's website, Dorothy Brown, and ask them to let you know when your court date is. Have your case number ready. Or you can look it up on the online docket through that same website. If you have your case number, you go to the civil division and enter your case number, and it should show you what the next court date is.
And just to reiterate what I mentioned at the beginning of today's presentation, we will be doing the same thing next week for landlords. Of course, we'll have to beef up security between now and next Wednesday, but we will be doing the same thing, having a meeting for Evanston landlords who want to know about their rights and resources and tips during COVID. So that's next Wednesday at 6. There will be information being sent out about that. And on May 6th, 6 p.m. May 6th, there'll be a Spanish language version of this renters' rights tips during COVID-19 for specifically Evanston renters. So I want people to keep that in mind as well. Did you have other questions for us, Javier?
Yeah, got a few more. Okay, so here's another one. What recourses do tenants have with regards to rents being raised excessive amounts? For example, a $200 rent increase.
Well, I mean, I'm assuming that's happening now, which is really, really unfortunate and I imagine frustrating because, one, there is currently no law preventing a landlord from increasing rent, by what a lot of people would consider a very unreasonable amount. There's nothing illegal about raising rent $200, provided that they gave proper notice of that rent increase. So if they're in the middle of a written lease, the landlord can't raise the rent, but if they're about to renew or they're being offered a new lease, it is legal to raise the rent. So we would encourage the tenant certainly to try to open up a line of communication. We MTO organizers would be happy to talk one-on-one with a renter in that situation to go over kind of what leverage they might have, whether that's anything that maybe the landlord has or hasn't done in the past that they could use to come to a compromise. And oftentimes it's just helpful to have outside eyes and ears giving some experience that aren't personally involved, because really there's usually and almost always better to come to an agreement with your landlord as opposed to have a knockdown, drag out, brawl over something. So in that situation, I would tell them to call us, but also try to open up a line of honest communication with the landlord.
Yeah, and I would just add one thing to that. Phil's correct that there's nothing preventing a landlord from raising your rent as long as they're doing it for a permissible reason. If you feel like your rent is being raised because you've been complaining about the conditions in the property or otherwise exercising your rights as a tenant, then that could be unlawful retaliation, and then the landlord would not be permitted to do that. But that's a little bit of a tricky question, and you should certainly contact MTO or LCBH if you believe that that's the case.
Okay, here's another one. Okay, should a Spanish-speaking tenant ask for a Spanish-speaking officer during a lockout?
Did they say, can a Spanish-speaking tenant ask for a Spanish-speaking officer?
Should the tenant ask for one? Yeah.
Well, I mean, that could be a very, it's very situational. I would say yes, but if that means that whoever's there is going to leave, it might be advisable to try to get someone else, maybe a neighbor or someone on the phone that could translate, if possible, or if possible, when they're calling and requesting an officer on scene, to ask to let them know or try to request that, because of course there's officers aren't always maybe aware of what they're supposed to do in a lockout situation or always willing to act on it. And so, if you do have an officer on the scene, hopefully you want to be able to communicate what's going on with them. And we always say, if you are a renter in that situation, or you fear you might be locked out, call us and get contact info for us so that you can send us a message or contact us directly when that happens. We have and are willing to help tenants advocate to the police to help end a lockout.
Here's another one. Can I break my lease if Evanston landlords don't attach the RLTO with it?
So I think that is a distinction between the Evanston RLTO and the Chicago RLTO. I think under the Chicago RLTO, failure to attach the summary of the RLTO is a cause for breaking the lease. I don't see that in the Evanston RLTO. There's a civil penalty of $200. If a tenant shows that it wasn't attached, the tenant can get their attorney's fees paid. But I don't see that same remedy under the Evanston landlord-tenant ordinance. So while the landlord is supposed to attach the ordinance, unfortunately, that remedy doesn't appear as available under the Evanston law.
Okay, got another one right here. Okay, so is locking a back gate considered a lockout?
So I think that's one of the kind of the tricky borderline lockout issues. I think, what we would argue is that reduces the tenant's ability to fully use the property and denies them an access that they had previously enjoyed, so that it is a lockout, and should be remedied like one. But it's a little bit of a borderline one in that the tenant is not being excluded from the property. They can still live in the apartment as long as they have access through the front. I think when we address issues like that, we tend to frame them both as a lockout issue and as a safety issue, because, it could certainly be a dangerous situation if there's a fire or something like that, and the tenant would need to leave the property through the rear exit and couldn't do so because the gate is locked. So, if you have that situation, your landlord has changed the lock on the back gate and hasn't given you a key or has otherwise blocked or obstructed that exit, I might contact 311 about that situation, in addition to demanding that the landlord give you a key. But you should be, if there are, you should be entitled to use all entrances and exits to the property, just as part of your tenancy and also as a safety issue.
And again, I would just add from kind of an organizing perspective, that's something that MTO is always happy to help with or advise tenants based on their own situation, as far as giving tips to just having a more of a less formal talk with the landlord and trying to hash this out without it escalating. A lot of times something as seemingly innocuous as a locked gate leads all the way to an eviction, which was totally avoidable. And that's what we really want to help tenants with, is avoid situations from escalating. Absolutely, you have a lot of rights, as you've seen from these presentations, but if things were going our way, you wouldn't have to exercise most of the rights that we went over today, because we could really nip these problems in the bud and prevent them from becoming bigger issues. So that's something we always like to tell people to keep in mind.
Yeah, Phil's absolutely correct about that. I mean, the first step always should be talk to your landlord, and try to work it out in a reasonable way. Doing things, while you're certainly entitled to call 311 and talk to the city, or send a formal letter or contact a lawyer, you can certainly do all of those things, but they can sometimes raise the temperature in the room and escalate the situation in a way that makes it harder to resolve rather than easier. So, the first step should always be talk to your landlord, and as Phil emphasized in his presentation, try to do it in a way that you can document, because that's going to help you down the line.
Okay, got another one that just came in. Can landlords charge move-out fees during COVID-19? I'm a college student, even if they have a federally backed mortgage.
So the landlord's ability to charge a move-out fee would be governed by the lease. If it's in your lease that there's a move-out fee, the landlord can charge you a fee. What the federal law prohibits the landlord from doing is charging a late fee during the moratorium period. So, between now and July 25th, they can't charge you a late fee, for the rent, for not paying the rent. But I don't believe that affects a move-out fee.
Okay, getting one more. Okay, here's another one too. In relation to late fees too. Can a landlord evict me if I refuse to pay the late fees during the COVID?
So that would depend on whether the landlord can lawfully charge you a late fee right now. So if you are have federal protection or some other kind of protection, there may be policies implemented at the state and local level that would affect this. That says you don't, the landlord can't charge you a late fee, then no, they can't evict you for not paying a late fee. If you're not protected in that way, late fees are considered rent under Illinois eviction, Illinois state law, and the landlord can file an eviction against you for non-payment of those late fees as rent.
Okay, here's another one. Can my landlord keep my security deposit if I can't pay the May rent?
So you want to handle that one?
Well, yeah, I mean, yes, and they likely will, but I guess that could depend on a lot of things. Is this person moving out or not? So there would be possibly some changes to that answer. I don't know if you have something more concrete, John, that you want to add.
So just in general, and this is a point where I haven't looked at the Evanston security deposit statute recently, so don't take this as gospel. Under the Chicago law, a landlord can deduct unpaid rent from your security deposit. So if you owed rent for May and didn't pay the rent for May, they could deduct the month of May from your security deposit, at the start of things, before then also deducting, whatever they would normally deduct for, damage to the unit, things like that. It's important to remember that is the landlord's election to deduct from the security deposit. You can't, as a tenant, say, well, I can't pay May rent, take it out of my security deposit, and I'll start paying again in June. That's not an election that the tenant can make, and the landlord could file an eviction against you for that money.
Okay, it seems like people are submitting questions right here in the side chat. Got a new one. What if you got a late fee before the pandemic?
So if there was a late fee prior to the COVID emergency, I mean, that's going to be like any other late fee. It's going to go on your ledger. It's going to be counted as rent, back rent that is owed, and you could get a 5-day notice for the amount of the late fee if it's not paid.
Okay, got another one in regards to inspections. Is Evanston backlogging building inspections, and how long do they take?
Well, I don't know the answer to that personally, if they're backlogged and how long it takes right now. But I can say that from experience, they are significantly faster than the city of Chicago, and will communicate with the tenants and coordinate if necessary to actually carry out the inspection. In the past, with Evanston tenants I've worked with, they generally have had an inspection done within a couple of weeks of requesting it. But that's, of course, is the regular situation. So I'm not sure how this COVID-19 situation has or hasn't lengthened the wait period, but generally it's much shorter in the city. And they also you can also do it online. So I encourage people to do that. You can also get your reference number. So request an inspection online, because also a lot of folks will call us and they don't have proof. Say they called the city and requested an inspection, and then their landlord gave them a 30-day notice out of retaliation. But the tenant didn't write down a reference number, had no way of proving it because maybe they missed the inspector. So always, if you can do that online, it's a great way to document things.
All right. Do we got any more right now for the time being?
I did get one other, this came through. Again, this is a reminder for landlords. Next Wednesday, we'll be sending out more information. We'll have a training for landlords in Evanston, tips and resources for how they can navigate this pandemic. And then the following Wednesday, again at 6 p.m., that's May 6th, we'll be having a Spanish version of the Renters' Rights app. So, again, questions about anything today, you can contact us and get those answered just by going to our website to that contact us form. Otherwise, you can leave a message on our hotline. We're actually going to be taking live calls again soon, but if you do leave a voicemail or send us an email, we'll get back to you within 24 hours.
Yeah, and just one note, on the contact us page, we've got LCBH Renovention there. Renovention is targeted at Chicago renters specifically. So, I would hate for Evanston tenants to go there and find it unhelpful. If you want to go through the process, it can help you generate a Form 14-day letter. But I think that it would probably be a better idea just to contact MTO's hotline. And then if you need legal assistance, contact us at our phone number, 312-347-7600, so that we can make sure that you're getting legal assistance that's appropriate to the city where you live.
Correct. And just for those who may have not heard throughout the presentation today, is MTO can provide sample letters that you can use as a template to create a letter to your landlord. Really for almost every situation, but certainly for any situation we've talked about today, whether that being you might not be able to make the rent due to the pandemic and a change in income, down to a basic 14-day repair request. Contact us. We can give you a template. That way you're not missing any key language.
Yep. Yeah. So that's our presentation right here. If you didn't get your question answered, feel free to contact us. Available Monday through Friday. We will, send this presentation out if, people want to, get a copy of it. And again, we apologize for the interruption, but, here's our contact information right here available for everyone.
Great. Yeah. And thank you I'd like to just thank also the city of Evanston who allowed us to get this information out. A lot of folks that are not in the city of Chicago don't know how to get a hold of this information. And so we really appreciate the city making an effort to get this information and resources out to the renters there. It's really good. So thank you.
We'll leave the screen right here up for like a little bit more, and then we'll end right now just so people can get the contact info. So leave it for a few more seconds and.
No, like Phil, thank you to the city of Evanston, and thank you to all the tenants who attended today, despite the efforts of random internet people to prevent you from getting this information. You've overcome.
Yeah,
we fought the trolls, so here it is.
Okay, yeah, that wraps it up, and we'll be ending right now.